And welcome to this webinar about interim relief. The PowerPoint slides and accompanying notes will be made available, and they include all the statutory implications. So, what's it all about? Interim relief sounds like an amazing deal for an employee who believes they've been unfairly dismissed. If they can persuade a judge that they're likely to win their claim at the final hearing, the judge can order their former employer to keep paying their salary until the trial. Given the lengthy delays in the employment tribunal system, surely making this application is a no-brainer for a recently dismissed employee. Anecdotal evidence suggests that interim relief applications are gaining in popularity, with the increasing number of employees losing their jobs and the pandemic making the already slow tribunal system even more sluggish. Many claims currently being issued won't be heard until 2022. But interim relief is a tricky business. A sacked employee has many hurdles to overcome and are rarely met. For employers, it's draconian because if they're ordered to pay for their former employee's salary, they can't recover that money, even if they ultimately defeat the claim. So the aim of this talk is to explain how interim relief applications work, the tests that must be overcome to succeed, and how respondents can best defend an application. Finally, I will consider the very recent and potentially significant decision in Steer and Stormtron Limited, which may lead to a dramatic expansion of the availability of interim relief. So, what is interim relief? In employment context, it's a mechanism whereby an employee who has been dismissed in certain situations can apply for an order that the employment relationship with their former employer continues until the final hearing of their claim. If they're successful, the applicant will either be given back their old job, given another job with the same employer, or failing that, will simply continue to be paid their salary until the final hearing. This is an unusual remedy. It's rare that the courts will compel an employer to continue to employ someone. It defends the principle that parties are free to contract or not to contract with whomsoever they wish. Interim relief has its origins in trade union law. As Lord Justice Devlin said in the case of Bombardier Aerospace, Short Brothers plc and McConnell from 2008, interim relief provisions were a response to the problem dismissals of trade unionists, which have the potential to generate suspicion and victimisation, which on occasion can result in industrial arrest and industrial action. An application for interim relief is intended to head off industrial trouble before it begins, or at least before it becomes too serious, by allowing an employment tribunal to give a preliminary ruling at an emergency hearing. Over time, the scope of the relief has expanded. It can now be sought in a number of situations specifically identified by Parliament as never being fair. It has become particularly popular in cases where an ex-employee claims they were dismissed for making a protected disclosure, or as it's widely known, whistleblowing. What types of dismissal allow an ex-employee to bring a claim for interim relief? An applicant must bring himself within the narrow confines of Section 128(1) of the Employment Rights Act 1996 by claiming that the reason, or if more than one, the principal reason for their dismissal, is one of a number of different types of claim as set out in Section 128(1). These include carrying out certain health and safety activities, carrying out certain activities as a working time workforce rep, performing the functions of a trustee of a relevant occupational pension scheme, performing certain functions as an employee representative for the purpose of a TUPE or redundancy consultation, whistleblowing, blacklisting, and various trade union reasons, such as obtaining or preventing union recognition. There is also a parallel provision for employees to apply for interim relief at Section 161 of TLRCA, the Trade Union and Labour Relations Consolidation Act of 1992. They claim their dismissal is unfair because it relates to trade union membership or activities under Section 152 of TLRCA. In most of these cases, an extra requirement, the applicant must provide a certificate signed by an authorised official of the union to certify the applicant's membership or proposed membership of the union, and that there appear to be reasonable grounds for alleging that their dismissal was for the prohibited reason. There are two further situations where interim relief can be claimed, and they're fairly unusual. First is dismissal in connection with the right to be accompanied at a disciplinary or grievance hearing, and that comes under Section 12(5) of the Employment Relations Act 1999. The second one is dismissal in connection with the statutory right to be accompanied at a meeting to consider a request to enter into study or training. That's Regulation 18.5 of the Employee Study and Training Procedural Requirements, Regulations 10. Some types of claim for automatically unfair dismissal do not provide a gateway to an interim relief application. For example, the claimant says that they were selected for redundancy because they made a protected disclosure. This does not allow them to claim interim relief, because Section 105(6)A of the ERA, relating to allegations that selection for redundancy was due to flow, is not one of the gateway provisions listed in Section 128 of the ERA. The selection process might make a redundancy unfair, but selection was not in itself the reason for the dismissal. And interim relief always focuses on the reason for the dismissal. Moreover, in a genuine redundancy situation, remedies offered, such as reinstatement, may simply be no longer available. So interim relief is only available in a narrow set of situations. The employee who claims he was unfairly dismissed for more common conduct or capability reasons cannot apply for interim relief. As is clear from the limited circumstances in which interim relief can be obtained, the guiding principle behind it is that these are activities that are considered to be in the broader public interest, not just in the private interest of the individual bringing the claim. Clearly, the right to trade union membership and to make whistleblowing disclosures are very much in the wider public interest. So what are the further requirements for making an interim relief application? Before you can get the application off the ground, it's essential that the applicant is an employee. Workers or the self-employed cannot obtain interim relief. Also, the claim must be brought within 7 days of the effective date of termination. If the employee is working their notice, they can make the application during the notice period. Of course, 7 days is a very tight time limit and it's not possible to extend it. However, the employee does not need to have 2 years' service, unlike with an ordinary unfair dismissal. They don't need any particular length of service to apply for interim relief. Also, the employee does not need to have gone through the ACAS early conciliation process before making that application. And if you look at the Form ET1, you'll see at box 2.3, an interim relief application is one of the exemptions to the requirement to complete ACAS early conciliation. To obtain interim relief under Section 129 of the ERA and Section 163 of TLRCA for trade union claims, the applicant must persuade the tribunal that it's likely that they will succeed at the final hearing in proving that the reason or the principal reason for their dismissal was the inadmissible reason they rely on. This is where most applications fail. It's a very high test. The word likely has been extensively considered by the courts. In Taplin and C. Shibham Limited, case from 1978 in the EAT, Mr. Justice Slynn held that in an application for interim relief, the tribunal should ask themselves whether the applicant has established that he has a pretty good chance of succeeding in the final application to the tribunal. He also made clear that the standard of proof is higher than that of a reasonable prospect of success. The result of this is that a claimant seeking interim relief has to reach a higher standard of proof at the interim relief hearing than applies at the final hearing. Despite challenges over the years, Taplin is still good law. For example, in the case of Dandpat and University of Bath, also an EAT case, with the President, Mr. Justice Underhill, presiding at that time, it was held, we do in fact see good reasons of policy for setting the test comparatively high. If relief is granted, the respondent is irretrievably prejudiced because he is obliged to treat the contract as continuing, pay the claimant until the conclusion of proceedings. That is not a consequence that should be imposed lightly. The claimant who successfully obtains interim relief but does not succeed in the final hearing is not obliged to repay the salary he received, even if he did no work for the employer between the interim relief and the final hearings. There's no mechanism to recover that money. This potentially punitive feature of interim relief is one reason the hurdle claimants must overcome is set so high. In the first instance case, Marshall and others and the Doctors Laboratory Limited, heard at Central London ET in July 2020, the respondent argued a novel point on which there's no authority. That because the money cannot be recovered if the claimant does not ultimately succeed, an order for interim relief is an interference with the right to property, as set out in Article 1 of Protocol 1 of the European Convention on Human Rights. Interim relief is a unique jurisdiction. without the provision of a cross-undertaking in damages, as would be made by the High Court when granting an injunction to continue an employment contract. Further, the order for interim relief is a blunt instrument that does not take account of the likelihood of any reduction that may ultimately be made if the claimant succeeds in respect of contributory fault or polky. For these reasons, the respondent and doctor's laboratory argued that the Taplin test should be applied even more stringently, and the claimants must show that they are practically certain to succeed at the final hearing. E.J. Goodman dismissed this argument, holding that the test already set out in Taplin and other authorities, which is higher than the balance of probability, is sufficient to protect respondents. The argument illustrates just how onerous an order for interim relief can be on a respondent. So what must the applicant show to obtain an order for interim relief? Demonstrate that it is likely, the standard discussed already, that they will succeed in making out their claim at the final hearing. The applicant must persuade the judge of this in relation to all the elements of the claim that will be considered at the final hearing. The burden is on the applicant to prove the case. So take a whistleblowing claim, for example, which is a common basis for an interim relief application. The applicant must succeed on each element of the claim. As Underhill P. put it in the case of Ministry of Justice and Safraz, in order to make an order under sections 128 and 129 of the ERA, the judge had to have decided that it was likely that the tribunal at the final hearing would find 5 things. 1, the claimant had made a disclosure to his employer. 2, that he believed that the disclosure tended to show one or more of the things itemised at A to F under section 43b(1). 3, that belief was reasonable. 4, that the disclosure was made in good faith. And 5, that the disclosure was the principal reason for the dismissal. Of course, since that decision, the good faith test has been replaced by a test of whether the applicant reasonably believed the disclosure to be in the public interest. So this rule does not apply just to the merits of the claim itself, but to all elements that must be proved at the final hearing. So, for example, if there is a dispute over the employment status of the claimant who seeks interim relief, which, as I referred to above, is only available to employees, the judge hearing the interim relief application should also consider the employment status issue and decide whether, on a Taplin basis, it is likely that the applicant will show they are an employee at the final hearing. And that's referred to in the case of Hancock and Terberg and another. This case also held that an interim relief hearing should not be delayed while an initial issue such as employee status is decided. All these matters should be decided at the interim relief hearing. Another example of what might be thought a preliminary issue being considered at the interim relief application is that of the alleged illegality of the contract. This, if raised, can also be considered and decided to the same Taplin standard. That's the case of Alcassini and Robertson. How should the respondent oppose an application for interim relief? The respondent may have very little time to deal with this application because under section 128(3) of the ERA, the tribunal must hear the application as soon as practicable after receiving the application, albeit it must give the employer at least 7 days' notice of it. It's very hard to postpone the hearing of this application. Under section 128(5), there must be special circumstances before that can happen, although the availability of a direct access barrister has been held to constitute special circumstances in the case of Lunn and another, and Aston Derby Group. So the respondent must act fast. Ideally, it should put in a witness statement, provide key documents going to the heart of what the respondent says was the fair reason for the dismissal. If the judge is making a broad brush assessment of the merits, it will be hard for an applicant to persuade the tribunal that it is likely that they will succeed at the final hearing. There's a cogent alternative narrative from the respondent. In a statement prepared for the interim relief hearing, there is no need to go too deeply into peripheral issues or procedural matters. Focus should be on the reason for the dismissal. Note, however, that as a fuller witness statement will no doubt be required for the final hearing, the statements for each hearing should be consistent with each other. If the respondent has time to put in the ET3 before the interim relief hearing, so much the better. But that's not expected, and it will not always be possible to get that ready in time. What happens at the interim relief hearing? Interim relief applications are generally decided at the hearing based on the papers before the judge and the parties' oral submissions. The usual rule is that no oral evidence is heard. Rule 95 of Schedule 1 of the Employment Tribunal's Constitution and Rules of Procedure Regulations from 2013 says that the tribunal shall not hear oral evidence unless it directs otherwise. But there's nothing to stop a party asking to cross-examine the other side's witnesses, but permission for this may not be granted, and hearings often have limited time. Rule 95 also says that Rules 53 to 56 regulations apply to interim relief hearings, and these provisions make clear that the interim relief hearing is a preliminary hearing to be heard by a judge sitting alone, although there is provision to apply for a panel, and it's a public hearing. The tribunal will inevitably have far less material before it than at the final merits hearing. Often, it may have nothing more than the claimant's ET1 claim form. Respondents are under no obligation to provide its ET3 response early in order to present it for the interim relief hearing. Although, as I mentioned before, an employer who can do that in time is well advised to do so. The authorities show that the judge hearing the application needs to make a brisk summary assessment based on the material available. As Mr. Recorder Lubeck UC put it in the case of London City Airport and Chaco, the employment judge must do the best he can with such material as the parties are able to deploy by way of documents and argument in support of their respective cases. What this requires is an expeditious summary assessment by the first instance employment judge as to how the matter looks to him on the material he has. This must of necessity involve far less detailed scrutiny of the respective cases of each of the parties and their evidence than will ultimately be undertaken at the full claim. And in Parsons and Airpass International Limited, His Honour Judge Shanks observed, on hearing an application under Section 128, the employment judge is required to make a summary assessment on the basis of the material then before her of whether the claimant has a pretty good chance of succeeding on the relevant claim. The judge is not required, and would be wrong to attempt, to make a summary determination of the claim itself. The decision will inevitably be based to an extent on impression. And perhaps for this reason, the judge who hears the interim relief application is not allowed to conduct the final hearing. What happens if the applicant succeeds at the hearing? This can be a heavy burden for an employer. As Section 129.3 of the ERA and 163.2 of TLRCA set out, if the applicant succeeds, the tribunal will ask whether the employer is prepared to reinstate them into their old job or to re-engage them on terms at least as favourable as those of their old job. The employee has to agree to any re-engagement, but if their refusal is considered unreasonable, the tribunal will not make any order in their favour. Reinstatement or re-engagement may not be appealing to an employer who may well not wish to have their former employee back in the workforce, having just dismissed them. If neither reinstatement nor re-engagement are possible, the tribunal will order a continuation of the contract, so the employer has to continue to pay the successful applicant but will not have the benefit of their labour. Note that a continuation order will also result if the respondent does not attend the hearing of the interim relief application. So the respondent, the employer, must not ignore the application. It will turn out to be an expensive mistake. If there's a significant change of circumstances after the interim relief hearing, but before the final hearing, either party can apply to the tribunal to vary or revoke the order made. I imagine that would be cases of where, for example, the claimant is found other work or the respondent is in financial trouble. If an employer fails to comply with an order for reinstatement or re-engagement, the employee can apply for an order for continuation of the contract and for compensation. Suddenly, interim relief is having a moment in the spotlight. In December 2020, just before the end of the Brexit transition period, Mr. Justice Kavanagh heard the interesting and potentially significant case of Steer and Stormtron Limited in the UK. The date of the hearing was important because after the 31st of December 2020, the effect of EU law on domestic legislation is effectively frozen. So Mr. Justice Kavanagh made a particular effort to hear the case while his judgment could still apply in England and Wales were he to find in favour of the appellant. The case considered whether interim relief should be available in cases where the employee is dismissed as of discrimination or victimisation. As set out above, that's not currently permitted, and to extend interim relief to this larger class of claims would be a hugely significant development. Miss Steer had been dismissed on grounds which she said amounted to sex discrimination and victimisation. She sought interim relief, which of course is not currently available for such claims, and so the tribunal, unsurprisingly, dismissed her claim. She appealed to the EAT on the basis that interim relief should be available under the Equality Act 2010. And the fact that it wasn't meant that the Equality Act was not compatible with EU law or the European Convention on Human Rights. Mr. Justice Kavanagh did not agree that the EU law principles of effectiveness and equivalence were infringed by the fact that interim relief is not available for discrimination claims. However, he did conclude that this situation was a breach of Article 14 of the European Convention on Human Rights, which is the prohibition of discrimination, when read with Article 6, which is the right to a fair trial. The government had not chosen to intervene in this case, so Mr. Justice Kavanagh was unable to discern whether there was a justification for the difference in treatment between claimants in discrimination and victimisation claims and those in whistleblowing. Section 4 of the Human Rights Act 1998 gives the power to make a declaration of incompatibility between domestic and European law, which invariably leads to the government amending domestic law to render it compatible. However, the EAT does not have the power to make such a declaration. It has to be a higher court. Justice Kavanagh therefore gave permission to Ms. Steer to appeal to the Court of Appeal so that it can consider this issue further and, if appropriate, make the declaration of incompatibility. So what might be the result of Stormtron once it goes to the Court of Appeal? If interim relief became available in cases of dismissal arising out of discrimination or victimisation, it would be hugely significant. Justice Kavanagh said that this would have major policy and practical consequences, the effects of which the EAT is not equipped to evaluate. He explained this by reference to 8 likely results, and the most significant would seem to be these. It would broaden interim relief so it was available to workers as well as employees, potentially leading to huge practical consequences. It would likely lead to a far larger number of interim relief claims being brought, perhaps leading to further delays in the tribunal system. Interim relief may be sought in multiple claims, for example, rising out of a large-scale redundancy exercise in which it's claimed that selection criteria are indirectly discriminatory on grounds of sex. The range of issues which the ET will potentially have to address at the interim relief hearing would be much wider, and given that discrimination claims can be nuanced, may lead to far more complex hearings in order to establish that the claimant has a pretty good chance of succeeding at the final hearing. Claimant's ability to bring these claims will affect the balance of power between claimant and respondent, and for example, it may make respondents more likely to settle even in unmeritorious cases. So for all these reasons, the Court of Appeal decision will be awaited with particular interest. I've put together on this slide some tips for claimants. Perhaps the most important is to act fast. Application for interim relief must be submitted within 7 days of the effective date of termination. If you've only got 7 days, you can't extend that. Here I've put together some top tips for respondents. And perhaps the most important is the last bullet point: turn up. Failure to attend the hearing automatically results in an order being made in the claimant's favour, so you must get there somehow or other, even if you haven't had time to put in any documents. Thank you for attending.
Well, hello everybody. Very nice to see you all, so to speak. I can't actually see you, don't worry, but I know that there are some 80 of you who've been listening to the presentation. I hope you found it informative. There may have been a few slight glitches with the sound, so we will be providing all the notes and the PowerPoint slides afterwards, detailed notes, so don't worry if you weren't able to catch everything. And I believe the video will go up on YouTube, and we'll make sure the sound is good at that point. Thank you very much for the people who've been putting some questions into the Q&A. So I'm going to just try and answer some of those questions now. I've got some very good questions from Shahzad Ayub. Thank you for those. First of all, a good introductory question. At an interim relief hearing held by the ET, are directions given in advance to the parties? Well, the whole point of interim relief applications is that they're what you might call quick and dirty. So you don't get very much time, although, as I said in the talk, the respondent must have 7 days notice. So what's likely to happen is you simply get a notice giving you the date of the interim relief hearing. You might not even get the standard notice of a claim, which gives you the date for providing the ET3. Although if you do get that, of course, make sure you comply with it by the relevant date. So, you know, you don't tend to get directions for bundles, statements, etc. It can be just slightly more than 7 days before you actually go to the hearing. It can happen really quickly, which is why it is, as I say, a bit of a quick and dirty type of hearing. Any directions that are given, obviously, you need to follow, but probably you'll simply be given the time and place to attend, which leads to sort of related questions. Given the pandemic, would an interim relief hearing be amenable to being conducted on CVP, the cloud video platform? Absolutely, yes. That's a very common way of hearing all sorts of hearings at the moment. And in fact, interim relief is a particularly good type of hearing for CVP, I would say, because it tends to be submissions. It's rarely oral evidence or live evidence. And therefore, it works very well on CVP. The last interim relief hearing I did was on CVP. So thank you for those questions. Now, the next one I've got from Shazad also. In my experience, how quickly are interim relief hearings convened by the ET after acceptance of the ET1? Well, I can give you an actual example because I did a hearing last summer where the person concerned was dismissed on the 21st of May and brought a claim within the 7 days that she must bring it. And we had the hearing on the 8th of July. And I think that was probably a bit slower than you might expect because of the pandemic, which was obviously affecting things at that point. So you can see it comes around much more quickly than the final hearing of the matter is going to be. After all, final hearing these days is likely to be, of any claim, is likely to be well into 2022 already. So it usually comes on pretty quickly. So thanks, Shazad, for those questions. Now, I've got a good number of questions. Susan Chan, Susan, hello, has put up a very good question. If the interim relief application fails, does the claimant then have to go to ACAS conciliation before continuing with a substantive claim? I believe that's a no to that one. The hearing I did, we discussed that afterwards, and the judge said it wasn't necessary. Obviously, you're welcome to go to ACAS at all stages to try to conciliate, but you don't have to fulfill those requirements that you would normally fulfill when bringing a claim without interim relief application. So now we have a question from Karen Fain. Hello, Karen, thank you for your question. I might have sort of dealt with it in the talk, but let's see. The question is, if you're successful in claiming interim relief, do the implied terms as to mutual trust and confidence and payment of bonuses continue as before the dismissal? To answer that, I just go to the words of section 129 and 130 as to what happens when an interim relief order is made. So the tribunal goes through things in order: reinstatement, if not; re-engagement, if not; continuation of the contract. So for reinstatement, it says at 129(3)(a), that is to treat him or her in all respects as if he had not been dismissed. So essentially, you're back to the situation you were at when before you were dismissed. For re-engagement, it's slightly different in that they have to be re-engaged in another job and specify the terms and conditions on which that job will take place, and the employee has to be willing to accept the job on those terms and conditions. And so, again, it's likely that they will be very similar to the existing situation before the dismissal. And then finally, the order for continuation of the contract, if neither of those arrangements are acceptable. Section 130 tells us that the order is that the contract of employment continues in force for the purposes of pay or any other benefit derived from the employment, seniority, pension rights, and other similar matters, as it was before, essentially. So I hope that helps. Essentially, the short answer to your question would appear to be yes. I've got a couple more questions to look at now. Thank you for being such an engaged audience. So I've got a question here from Zakia Mariam Tahir. We received notice of an interim hearing to attend in September 2021. That seems a long way away. This was issued with a notice of claim, but no directions to respond to the interim relief were given. So I think that's a similar point to the one that Shazad raised earlier. It seems that you're concerned that there were no directions provided for the interim relief hearing, yet you've got this very long gap in time between now and September 2021, if I've understood that correctly. That seems extremely surprising that they would make you wait so long for an interim relief hearing. If you're for the claimant, I imagine you'd be writing into the tribunal saying, come on, hurry it up a bit. If you're for the respondent, you're probably delighted because you're avoiding the risk of having to pay their salary for these next 8 or 9 months. But it seems to me that although the tribunals are very busy, you're still entitled to contact the tribunal and ask for directions. This is a long time period. Turning now to a question from Cormac Devlin. Hello, Cormac. Do you think it's helpful to put a percentage on what constitutes likely? E.g., in Mihaj and Sodexo, the EAT accepted a 51% chance of success at the final hearing, satisfied the likely threshold. Well, I'm not familiar with that case, but my understanding of the Taplin test is that you have to be substantially higher than 51% in order to succeed in your interim relief claim. The irony is you sometimes need to have a higher sort of percentage, so to speak, to get interim relief than you do to actually succeed at the final hearing, where 51% threshold is often what's correct. I don't think you can put a percentage on it. It's more of a feeling, I'm afraid, which isn't a very helpful, perhaps not a very helpful answer, but I say the authorities show it needs to be higher than 51%. Right, I've got more questions coming in by the minute, so bear with me while I just take a look at them. Right. Lee Jeffcut. Hello, Lee. A good question here. Can continuation orders be appealed? What can an employer do if they're on the receiving end of one to lessen the liability? Oh, this is a great question because I've been thinking about this in the context of the pandemic, actually. So, first point, can continuation orders be appealed? Well, yes, of course you can bring an appeal, but the possible difficulty you've got is because, as I say, it's a sort of quick and dirty assessment. The case law accepts that the judge is going to be doing a broad brush look at the evidence before them. It's going to be really difficult to appeal that unless there's obvious perversity or a completely cracker's decision. That's why it's such a dangerous thing for an employer. But Lee, the second part of your question is very good. What can an employer do if they're on the receiving end of one to lessen the liability? Well, I was wondering if you could furlough someone if you're ordered to reinstate or re-engage as a result of an interim relief application. I don't know if anybody has thought about that or has heard of that happening. I haven't, although of course it's all such new territory that we're in. But that's quite an interesting direction of travel, it seems to me, because we've got the 3 possible outcomes for a successful claimant. First, reinstatement, second, re-engagement, and failing either of those being acceptable, continuation of the contract. Under continuation of the contract, the employer has to continue paying the employee, but they don't get any work in return. And of course, often the parties don't want to go back into working together because clearly the relationship has broken down if the claimant has been dismissed. But the pandemic does change that. You can see that there's an argument that the employer ordered to reinstate or re-engage may do that and then simply put the relevant person, the claimant, on furlough. So that means that the taxpayer is picking up the bill for interim relief. I don't know if anyone has any thoughts about that. I think it's an interesting possibility. I'm not sure it's a great outcome for the taxpayer. The other thought that occurred to me in terms of sort of lessening the liability, as I say, the parties often don't want to go back into a working relationship because it's broken down, there's bitterness and rancor, the water cooler chats are going to be tricky, but nobody's working in the office anymore, are they? So many people are working from home. If it's the type of job or office environment where working from home is a possibility, perhaps it's sensible then for the employer to try and get a bit of work out of the claimant by reinstating or re-engaging and getting them to work from home. That would reduce the, not perhaps eliminate, but reduce the possible difficulties of tricky interactions with colleagues, because at least they are not in the same physical workplace. Some interesting possibilities there. So Lee, thanks very much for that cracking question, because I think that leads to all sorts of possible lines of discussion and tactical possibilities. But you're absolutely right. The underlying point of your question is that it's a really hefty penalty potentially for any employer on the receiving end of an interim relief order, which is why it's absolutely vital for employers to get to grips with these applications the minute they come in the door, possibly without very much time to prioritise getting some evidence ready for that hearing and if possible, providing the ET3 if there is time to do that. Now I've got some more questions coming in, so bear with me while I just look at those. And yes, so Shazad, who I think is this week's winner for the number of very good questions that you provided, thank you. The question is, regarding the 7-day time limit for pursuing interim relief being missed, can the claimant rely on an extension on reasonable practicability grounds? That's a no. The 7-day time limit for bringing your interim relief claim is completely strict. There is no possibility of extending that. The only possibility for getting more time is if you're being dismissed with notice, and so you have some time leading up to the effective date of termination. You can put your claim in during that period of time, but once you've got to the effective date of termination, you have only 7 days. There is no possibility of extending that. That's why it's such a, as I say, quick and dirty, brutal sort of process. Can't hang around on either side. So Shazad, thank you for very good questions. I'm just going through the others that are literally coming in as I'm talking to you. Yes, Dean, hello, Dean Fuller has put in a very interesting point. LLP members and Limb B workers can blow the whistle, but cannot claim interim relief, which is only available to employees. Any thoughts or observations? Well, Dean, yes, you're absolutely right. Interim relief is only available to employees. We see over time that interim relief has sort of grown and expanded. So it started out in, I think, the early 70s as being a trade union relief, a way of trying to stop unionised workers going on strike, you know, one out, all out, a way of calming things in the industrial relations situation. It was obviously then extended into a certain number of automatically unfair dismissal claims, such as whistleblowing for employees, as you rightly say. What's the big question mark hanging over interim relief at the moment is coming out of this case of Steer and Stormtron, which I mentioned in my talk, which was heard in December in the EAT and is now going to go to the Court of Appeal. And the Court of Appeal is going to be asked to extend interim relief to discriminatory dismissals, in other words, dismissals arising under the Equality Act 2010, and of course that will extend it to workers at that point. That's going to be an absolutely huge change. I have no idea if the Court of Appeal is going to go for that. It's such a potentially fundamental change to the availability of the relief. And it has huge knock-on implications for the tribunal system, which, as we all know, is already really struggling, creaking, and struggling to cope with the claims before it now. My thoughts and observations are, I suppose, Dean, watch this space to see if the relief is extended to that wider group. Thank you for that. Sorry, I'm just going through to see the other questions. You say the tribunal, here's a question from Amy. Hello, Amy. You say the tribunal will make a continuation order if the respondent doesn't turn up. Presumably, if the respondent doesn't turn up, the claimant cannot satisfy the Taplin test, the tribunal wouldn't grant interim relief anyway. Well, my understanding is that they jolly well might, and you really do need to turn up, or you might have an order against you. Yes, so it's in section 129, subsection 9. If on the hearing of an application for interim relief, the employer fails to attend before the tribunal, the tribunal shall make an order for the continuation of the employee's contract of employment. Seems pretty black and white. It's extremely risky to not turn up if you're the respondent. So, Amy, thanks for that. I'm just looking through the questions to see if there are any more. Yes, we dealt with that. Lee, we dealt with your question. Amaya Corquera, I hope I pronounced your name correctly. There's a question here. If interim relief application is successful, would payment of salary and other benefits be backdated to the EDT? Oh, that's a very good question. I think the answer is yes. Yes, I think that's correct, because the idea is that you treat the employee as though they've not been dismissed. I would need to double check to be absolutely sure, but I think that's correct. It's an expensive business for the employer. So I'm just flicking through the questions to see if there are any that I haven't answered. I think I've answered everybody's questions. Yes. So it's all gone suspiciously quiet. And I don't know if anybody has any thoughts about this business of furloughing the person who gets interim relief. It's definitely a tactical point for a respondent to consider. Given that we've now got through all the questions, and thank you everybody for all your fantastic questions. There have been about a dozen really good questions, and I hope I've answered them helpfully and correctly. I'm going to be bringing the webinar to an end now. As I say, the notes, PowerPoint slides, and indeed the video are all available through our YouTube channel, and we'll be sending out the handout. So I hope you find that useful. Thank you all very much for your for attending. Karen's put a very nice message in the chat. Thank you for the presentation. I appreciate that. I think it's a very good, timely and topical subject. We're only going to see an increase in these sorts of claims. So thank you very much for your attention and engagement. It's been a pleasure to meet you all virtually and answer your questions. I'll now bring this to an end. Thank you very much. Good evening.